All right, Donald Trump thought the Supreme Court would save him. For months, his legal team promised a rescue. Right now, those 9 justices just delivered a decision that changed everything. The immunity he claimed, the protection he demanded, the shield he swore would hold, gone. What happened in the courtroom is the story everyone's trying to understand, because this isn't about one ruling. This isn't about one case. This is about the highest court in America, looking at a former president and saying something nobody thought they'd hear. The Constitution doesn't protect you from this. That's what they ruled. And when you see what happens next, you'll understand why Trump's entire legal strategy just collapsed in real time. So, what pushed the Supreme Court to this moment? One question, one argument, one claim Trump's lawyers never should have made. He said he was immune from prosecution for everything he did as president. Not some things. Everything. But here's the thing. This wasn't just about legal theory. This was about whether one person could rise above the law, and the court was watching closer than anyone realized. And I'm going to show you exactly how their answer to Trump's defense, like it was made of paper. See, most people think this case started with the indictments. It didn't. It started with Trump's own actions, his own choices, his own belief that the presidency made him untouchable. The moments after January 6, when he claimed executive privilege would shield him. The classified documents he took to Mar-a-Lago, insisting presidential immunity, covered it all. The pressure on state officials to overturn elections, arguing the office itself was his protection. That's not constitutional interpretation. That's not legal precedent. That's a gap so massive between law and reality, you could fit the entire federal courthouse inside it. And that was just one argument, one claim, and a mountain of assertions that legal scholars spent months dismantling. The moment everyone's talking about, the ruling that could end his immunity claims forever. It's coming. But first, you need to see what led the Supreme Court to reject his argument. Because when you understand the stakes, when you see how far Trump pushed, and how clearly the justices pushed back, the decision won't just make sense. It will seem inevitable. Here's what actually happened the moment the opinion dropped. April 25, 2024. The Supreme Court building in Washington. The air was electric with anticipation as legal reporters refreshed their screens, waiting for the decision. Trump wasn't there. He was at Mar-a-Lago surrounded by advisors, acting like this was just another legal hurdle. He declared. You could see it in every interview. That signature defiance. That absolute certainty that the court's conservative majority would protect him. But inside that building, something different was unfolding. Chief Justice John Roberts walked to the bench with an opinion that ran over 100 pages. Pages of constitutional analysis, pages of precedent, pages that would reshape presidential power forever. He didn't speak in absolutes, but what he said cut deeper than any dramatic pronouncement. The president is not above the law, he began, and then he delivered the framework that shattered Trump's defense. Presumptive immunity for official acts, no immunity for unofficial acts. Case remanded to determine which is which. The legal world didn't gasp. Scholars who'd been watching knew total immunity was never realistic, but what nobody expected was what came next. The justice said Twas warning that rang through every news channel within minutes. The president is now a king above the law. She wrote, with fear for our democracy, I dissent. But here's what everyone missed in the immediate chaos. Roberts hadn't given Trump what he wanted. He'd given him a fight, because now every single action Trump took has to be examined. Categorized, defended, official or unofficial, protected or prosecutable. The Supreme Court didn't save Trump. They gave prosecutors a roadmap to go around him. The framework was clear but devastating. Presidential immunity exists for core constitutional duties. Absolute immunity there. For other official acts, presumptive immunity that prosecutors can overcome. For private acts, no immunity at all. And who decides which category each action falls into? The lower courts, the same judges Trump has been attacking for months. One constitutional law professor who watched the announcement put it bluntly. Trump's team wanted a shield. Roberts handed them a sieve. Every hole is a potential prosecution. The actions Trump had taken, the pressure campaigns, the document handling, the election interference. Roberts' framework meant each one would be scrutinized individually. Trump had claimed his presidency covered everything. The actual ruling said, prove it. Prove each action was official. Prove each decision was within presidential authority. Prove it wasn't personal, political, or criminal. And the classified documents case, that example, the justices specifically addressed. taking classified materials after leaving office and refusing to return them. That's not official presidential conduct. That's not even close. That's personal action. Zero immunity. Full prosecution possible. This wasn't incompetence. This wasn't splitting legal hairs to avoid a hard decision. This was the Supreme Court drawing a line and daring Trump to cross it. And for the first time in this entire legal saga, the highest court in America refused to be his escape route. The opinion detailed how presidential power has limits, how no office grants blanket protection, how the Constitution itself demands accountability. A president's alleged criminal scheme to overturn an election and thwart the transfer of power, Roberts wrote, implicates his role as commander-in-chief, but it also implicates private capacities. The courts must sort them. But here's what changes everything about this story. This wasn't a loss. It wasn't a win. This was a delay wrapped in complexity. And Trump's team knows exactly how to use that. Because while legal scholars debate official versus unofficial acts, Trump is doing what he does best, running out the clock. But not everyone sees it that way. Trump's defenders are calling this exactly what they've called every legal challenge, a temporary setback before ultimate victory. And honestly, when you hear their argument, you understand why millions still believe he'll walk away untouched. Here's their case. The court said, presidential immunity exists. They acknowledged it. They protected core constitutional functions. They didn't throw Trump to the wolves. They created a process, and processes take time. Time that runs past the election. Time that could make all of this disappear if Trump wins. One legal commentator supporting Trump put it this way: Roberts just handed Trump the election. These cases won't be decided before November. If he wins, they vanish. Presidential immunity becomes real immunity. Self-pardon, case dismissal, everything. They're not wrong about the timing. Every legal expert agrees this opinion creates months of additional litigation. Lower courts have to hold hearings on each challenged action, determine if it's official or private, make findings, write opinions. Those get appealed back to circuit courts, potentially back to the Supreme Court. That's not weeks. That's not months. That could be years. And here's the uncomfortable truth. The Supreme Court knows this. They saw the calendar. They understood that sending everything back to lower courts for Case BA's analysis means delay. Whether they intended it or not, they've given Trump the one thing he needed most: time. This is a ruling designed to look fair while being devastating to actual accountability, one former prosecutor explained. But Trump's team has a point. It might just work. Critics are already calling this judicial cowardice disguised as thoughtful analysis. Why couldn't they just say no immunity for criminal acts? Why create this complicated framework that requires endless litigation? So, who's right? Did the Supreme Court actually preserve the rule of law? Or did they just show what happens when the legal system protects its own at the expense of justice? That's the question that keeps getting more complicated. And the more you dig into this ruling, the messier it becomes, because there's another layer to this story that most coverage completely ignores. But this didn't come out of nowhere. Years before this Supreme Court opinion, the groundwork was being laid. Back in 2019, Trump's own Justice Department issued a memo saying sitting presidents can't be indicted. The reasoning was simple but devastating. It would interfere with their constitutional duties. But Trump isn't a sitting president anymore. That protection expired January 20th, 2021. Yet, here we are years later still fighting about whether he can be prosecuted. Did prosecutors listen to the warning signs? They waited. Years passed. The January 6th committee investigated. Evidence mounted. Witnesses testified. And still no indictments. Not until 2023, 2.5 years after Trump left office. Jack Smith finally moved. The federal indictments dropped. January 6 charges, classified documents, charges. But Trump's team was ready. They'd spent those 2 years preparing the immunity defense, building the argument, laying the foundation. And when the indictments came, they immediately claimed presidential protection. Every court Trump went to, he made the same argument. Everything I did was as president. All of it official, all of it protected. The district courts rejected it. The appeals courts rejected it. But Trump kept appealing, kept fighting, kept delaying, and then the Supreme Court agreed to hear it. That decision alone, just agreeing to take the case, delayed everything by months. Oral arguments weren't scheduled until late April. The opinion didn't drop until the end of June. Trial dates that were supposed to happen in March got pushed indefinitely. Former prosecutors who reviewed the timeline admit they were outmaneuvered. "We gave him time to build the immunity argument," one said. "By the time we moved, his legal team had perfected it. That was the trap. The delay was the strategy." Every day that passed made election interference less likely to be resolved before the next election. And when the Supreme Court took the case, Trump's lawyers knew they'd won something crucial. Time for the justices heard oral arguments in April. Trump's lawyer stood before them and made claims that would have been laughed out of court a decade ago. Can a president order SEAL Team 6 to assassinate a political rival? Could that be immune? The question came from Justice Sawyer, and Trump's lawyer said, "It depends on the circumstances." The courtroom went silent. But 3 months later, the ruling came, and it didn't completely reject that possibility. The stage was set. Trump just had to survive long enough to make it irrelevant. And then it happened, June 2024. The immunity ruling. Roberts' opinion that seemed measured, but changed everything. The legal world exploded. Constitutional scholars wrote emergency analyses. Law professors canceled classes to discuss the implications. News networks ran 24-hour coverage. Everyone trying to understand what the court had actually decided. Because here's the thing, Roberts wrote for the majority, but even the conservatives weren't fully united. The decision was 63 on presidential immunity existing, but the application, the details, the framework, that's where it fractured. Justices writing separately, emphasizing different aspects, creating confusion about what's actually protected. Trump's first reaction from Mar-a-Lago was pure confidence. "Big win for our Constitution and democracy," he posted. But his lawyers knew better. They immediately started strategizing how to use the ruling to delay every case further, and that's exactly what happened. Jack Smith's January 6 case ground to a halt. Back to Judge Tanya Chutkan to hold hearings determining which acts were official. The classified documents case, already facing issues in Florida, gained another defense layer. The Georgia election interference case, now complicated by questions of presidential immunity bleeding into state prosecution. 78 days. That's how long ago the immunity ruling dropped. And in those 78 days, not one Trump trial has proceeded. Not one case has moved forward significantly. Every prosecutor hit the same wall. Prove each act was unofficial before we can even discuss evidence. And Trump's team is running out the clock masterfully. Every hearing they request gets granted. Every argument they make requires a response. Every motion creates delay. The defendant's strategy is transparent, Judge Chutkan wrote, but the law requires we address these questions. This was an emotional reaction. This was judges watching a former president use a Supreme Court ruling to dismantle the prosecution schedule, piece by piece. And the next phase of this tells you everything about what's really happening behind closed doors. People who do this for a living are calling this the most successful legal delay tactic in modern American history. One former federal prosecutor, someone who's watched courtroom strategy for decades, explained it this way. Trump didn't need to win at the Supreme Court. He needed to not lose completely. And Roberts gave him exactly that, a ruling complicated enough to require months of additional litigation. By the time courts sort out what's official and what's not, the election will have happened. What does that mean in plain English? For decades, presidential accountability meant consequences. Eventually, investigations would happen, trials would proceed. Justice might be slow, but it would come. This ruling says, maybe not. Maybe if you can delay long enough, win an election, regain power, justice never comes at all. And here's what legal experts are saying to each other in private conversations. If this strategy works, if Trump wins the election before any trial concludes, the president is terrifying. Future presidents will know the formula. Commit crimes, fight immunity, delay, run for office again, win, escape. But it's not just defense attorneys celebrating the complexity. Some prosecutors admit the court's framework makes sense theoretically. Presidents do need some immunity for official duties. The problem is the application. Determining what's official requires litigating Trump's intent, his motivations, his state of mind for every single action. That's not a trial. That's 1,000 mini-trials before the actual trial can begin. And each one creates appeal opportunities. Each ruling can be challenged. Each determination questioned. The layers are infinite. The message is clear. You might be guilty, but we're going to make proving it so complicated, so time-consuming, that it might never happen. So, what does this mean for you? Right now, prosecutors are scrambling. They're holding immunity hearings. They're categorizing actions. They're building records proving each charge involves unofficial conduct.